Well, good morning, everybody. Morning. Okay, I know we know this is a boring topic, but come on, guys. Okay, so we've lost one person. This is in the pursuit of gender equality. I'm sitting in the middle. My role is to be moderator, but like anything I do in life, I'm not going to do it like a normal moderator. First of all, I'm going to introduce my esteemed colleagues, John and Lee. We're going to give you a bit of introduction about who we are and what we do, and then we're going to get into this great conundrum of challenges about what we see about regulation, and hopefully you're going to learn something. So I'm going to make sure, because I can talk the leg off an iron pot, so I'm going to make sure that I'm on time. So I thought we'll start with John.
So John Salmon, I'm a partner at Hogan Lovells, and I lead our global blockchain and digital assets practice. And I guess we advise, so as a practitioner, we advise lots of clients from startups to big financial institutions and lots of people in between. And we also advise policymakers and regulators on this so-called regulation conundrum and how we apply existing regulation to blockchain, and also to what extent laws and regulations need to change, which I guess we'll discuss today.
Hi everyone, I'm Lee Schneider. I'm the general counsel at Block One, which is a blockchain software company. I've been a financial services and technology lawyer for more than 25 years, always based in New York. And I spend a lot of time trying to be a nuisance with regulators and entrepreneurs and anybody who will spend time listening to me. Because I think the biggest point right now is we've got to get out and educate people on what is going on in the blockchain space. So that's why I think conferences like this are hugely important, and frankly I wish more regulators and policymakers would show up at these so that they could see what's going on the ground.
So my name is Loretta Joseph. As Jane said, we're long friends, and I just have to have a big shout out to Jane for organising this, because I think she's done an amazing job. I tell you, I've been in 9 countries in 7 days, and this corona thing is a little bit excessive. We've run out of toilet paper in Australia. I'm still trying to figure out why that is and how that is, but that's another thing.
We have a lot in New York, so I'm happy to send you some if you need it, Loretta.
There's a conundrum about regulation. I'm just trying to figure out what the toilet paper issue is, but anyway. So thank you for all turning up, because I know that people are scared, and I think sometimes, I lived through SARS, and I've had typhoid, cholera, and tuberculosis, so don't worry. And I don't have corona. So I started my life, I'm a reformed banker. I was a derivatives trader in 1991. I started trading on a trading floor with a piece of paper and a pen. I got thrown into a group of 400 men on a trading floor. I traded a 3-year bond with a piece of paper and pen, had no idea what I was doing on an option. Went down, sat in the loo for 20 minutes, tried to figure out on a fax piece of paper what a delta hedge was, walked back and made $10,000. So way before we had computers, digital assets, and technologists that told me that they can do everything in financial services. So I've been a trader. I think I've traded every asset class known to man. To me, these new digital assets, as we're seeing, are just a new form of it. They're just another asset class. We've seen many asset classes come. I've never lived through the birth of one, but with digital assets, and I think a subcategory of that is a cryptocurrency, this is what we've seen. So fast forward, I ran a couple of banks globally. I ran RBS in India. I ran an investment bank called Elara Capital, and I set up an Australian bank, Macquarie Bank. So I come from financial services. I'm a banker, and I'm not a lawyer. I looked at blockchain in 2013, and I figured out in Australia that it could actually solve the processes and procedures of back offices and automate many of the processes in asset classes that we've never been able to do because we didn't have technology. I consequently looked that the Australian Stock Exchange had a monopoly on CHESS, the clearing and settlement system of Australia. So, as I do, I walked into the finance minister and said, "You need to change the law." And he said, "No, I don't." And I said, "Yes, you do." So I went back to the Australian regulator and I said, "You can give me administrative relief to make laws technology agnostic. Because if we're bringing in new technologies, laws need to be technology agnostic." So 3 months later, they did. So that was my introduction into blockchain. I then tried to buy some Bitcoin. Oh, good God. It was the most ridiculous thing that I've ever done. So I helped write the self-regulation for Bitcoin in Australia. I set up something called the Australian Digital Chamber of Commerce. So that's how I got into doing what I did. Fast forward to 2016 when every regulator kicked me out of the room. Every central bank thought that I had 9 heads. Nobody understood that this technology was the next revolution of the internet. And I remember having a conversation with the central bank governor of Canada. And I said, what's your biggest problem, Governor? And he said DVP, which is what we call delivery versus payment. The GFC happened because Lehman Brothers got delivered bonds before they paid for them. So instead of talking about the Bitcoin, I said to the Bitcoin guys who I took in with no socks, do you understand what DVP is? And they said, no, we don't. And I said, can you build a solution that solves the biggest problem for financial institutions and central banks? They said, yes, we can, but we didn't know it existed. So that was the day that I realised that the technologists are not policy writers and policy writers are not technologists, and they're not speaking the same language. Fast forward 2017, I met the Premier of Bermuda, tiny little country that sits in the middle of the Atlantic Ocean, 60,000 people. Interestingly, Google, Facebook, Uber are all domiciled out of Bermuda, and every 3rd car in the world is insured. The Premier said to me, come and please write law on digital assets. I said, well, I'm not a lawyer and I don't know where Bermuda is. He said, I don't care, come. The next day I jumped on a plane. In 3 months we wrote what we called the Digital Asset Business Act. It's the first legislation in the world around a digital asset, and I wrote the first regulation around an ICO, which I think stopped a lot of the problems that we were seeing with ICOs and the scammers, because what do regulators do? We protect consumers and investors. That's all we should do. But regulators are not technologists. So it showed me for the first time ever, if we put technologists and regulators in a room, we can all solve this problem. The internet taught us that walled garden approaches don't work. So now I've now written legislation and I work for more heads of state and central banks that I can count. Everybody's running at this. Every regulator is learning about this. Don't think they don't understand it, because they do. But there are challenges, because we're looking at a new asset class, and as I said, regulators are definitely not technologists. Blockchain and cryptocurrencies disintermediates. The first application of blockchain was obviously Bitcoin. It was a cryptocurrency. It's first, not the last. The exciting thing for me is that now we can tokenise every asset class known to man. We can open liquidity pools in markets that we've never seen in history. We will open new asset classes that is so exciting. Financial institutions got scared because they thought Bitcoin was going to take them out. Had Bitcoin called itself Zen token, not one central bank governor in the world would have been worried. The minute you put coin, money, currency into a sentence, everyone goes, oh. Had we called an ICO an initial business offering, because they're just a new way of digitally raising capital, nobody would have worried. So the technologists didn't word things properly. I argue with the crypto exchanges that they're not exchanges. I've set up market infrastructure. They are marketplaces. They match buyers and sellers. A security exchange is a public-private partnership, which is the utility of a country. So security exchanges have much more deeper law regulation, and that's a very good thing. We need to be aligned on what we talk about, so I think from education with policymakers, regulators, and the industry. So I'm going to ask you first, what are the challenges that you see in your jurisdictions legally that are causing the conundrum?
So, I completely agree with you, Loretta, that sort of technology, neutral technology agnostic is the way that regulators and policymakers should look at it, and generally do look at it. But that in itself does create an issue. And, I also agree that, this is like, I've been doing tech law, digital law for more than 25 years, just like Lee. And, having been through the internet, people talked about the internet being the Wild West. And that Wild West is unfortunately used in this space as well. And I find it quite irritating. But the reality is, I think 80% of the regulations and laws that exist for financial services, etc., whether it's 80% is the right number, but a big proportion can be equally applied to this crypto asset space without particularly changing very much.
Yep.
But there is 20% or whatever that number is that actually needs to change, because it is quite different. And I think just like the internet, you know, if you look at privacy law as an example of something that we actually think of has really changed, the fundamentals of privacy law have not changed pre-internet. You know, it's still the same law basically applies from, you know, files, brown files in a filing cabinet. It's actually the same broad principles. But obviously, you have to change it because everybody now stores it all over the world, and it's very easy to move data around in a way, you know, and do things with the data that no one anticipated when you had a brown file in a filing cabinet. So, and I think it's the same. There is a revolution, and I think the regulators and policymakers, and I completely agree with you that, you know, getting technologists and regulators together is an extremely helpful thing to do. From a practitioner's point of view, I think that the problem is that 20%, and often we get clients come in to see us and say, we have this protocol, decentralized protocol, say, or, you know, that we're running in this country, but we want to sell, you know, tokens or services in this other country. How do we do it? And it's very difficult often to apply that. And when, you know, you get clients say, we want to set up some form of exchange or bulletin board or whatever. Marketplace, let's, yeah. To trade security tokens, regulated tokens, and you say, well, you might really need to set up a multilateral trading facility in Europe, and you know, you've got to, the capital requirements are X, et cetera, and their kind of eyes roll into their head, and they, you know, oh, and by the way, there's these CSD regulations that you need to, so there are, I think, some really serious infrastructure problems and regulation that we need to look at, and we'll probably come back to this, but I think there's probably, we'll need to look at privacy law again. So I think there are that 20% is important, but I think the general principle should be applied, and personally, you know, and I hear regulators say this all the time, I think having a technology neutral approach is right, and also having an approach that doesn't favor digital assets and crypto versus the existing infrastructure, or vice versa, is also important. I think there should be a level playing field. You know, this is how people approach fintech generally, and I think this is the same.
No, agreed.
I think I'm going to demonstrate the regulatory conundrum right now, because I'm going to quibble with a little bit of what Loretta and John said.
Yay!
Great.
I actually think that financial services regulation should apply to financial services products or financial instruments or financial products or whatever you want to call them. I don't think it should apply to anything else. And as Loretta rightly said, the beauty of blockchain is that we can create digital assets out of anything. We can digitize anything. And that doesn't mean just financial instruments. We have to stop thinking about blockchain as being a financial technology. We have to start thinking about blockchain as being a database technology, as a digital uniqueness technology, and we have to say to ourselves, what are the functions and features of that particular digital item? And that's how we should regulate it. If it's a security, then let's regulate it as a security. But I don't want my identity regulated as if it's a financial instrument, unless somebody's going to pay me hundreds of millions of dollars.
Well, they might one day.
But even then, it's not going to be a financial instrument, right? Nobody thinks identity is a financial instrument, and this is the argument that I have in the U.S. all the time with regulators and many other people, because as you may all know, we have this this term in U.S. securities laws, investment contract, and there's this case, the Howey case, which no law student in the history of law students from 1946 when the case was decided until 2016, when people started talking about it, thought that case would ever be relevant for anything they did in their practice. And yet it has become this thing that, I mean, I go to conferences, technologists can quote you the test from the Howey case. Now, but the ridiculousness of it is what the Howey case said is there's this contract, transaction, or scheme that is an investment contract. And here's the test for when a contract, transaction, or scheme is an investment contract. It did not say that oranges and orange groves, which were the subject of the investment contract, were securities. And it's the same thing in the digital asset space, and what we've lost sight of in the US, and I think more generally globally, in the rush to financialize everything, is this idea that digital assets actually don't need to be financial instruments. So we really, really need people to be focused on, and we need lawyers and regulators to do what they have done throughout the ages, which is look at the thing, figure out what its legal wrapper is, and not judge it by its technology wrapper or any other wrapper that you put on it.
I mean, just to say, Lee, I completely agree with you, just to be clear, but that's what I'm saying about a level playing field. You know, because regulators do not regulate BA air miles or vouchers or whatever, right?
Yeah.
Which absolutely, so they should not regulate the digitized version. And actually, I think in the EU generally, we have a kind of more open approach than the US regulators do,
yes,
generally. But I actually think one of the things that I see in practice is that people say we're going to do utility token, but what they really mean is
they want to raise money.
They want to raise money as an investment for part of it. And that's where it becomes very difficult because they kind of get a bit muddled, you know, and then it becomes a problem. You pollute the utility token because you're also raising some money as a pure investment.
And just on that point, too, so when I've been a securities trader for many years. I've traded many asset classes. So when ICOs came in and these people were telling me they were a utility token and they were going to build the next Google 20, but what they really wanted to do was raise money. I understand security. So if you look like a security, it's like a duck. If you quack like a duck, you walk like a duck, then you're probably a duck. And that's okay. That is okay. But what regulators were struggling with was that people were saying that they weren't wanting to make investments, they weren't wanting to make money, they were going scamming people, they were raising money and not building anything. So I looked at the model, and what I did in Bermuda, I was like, so what if now we have hybrid models of something can start its life to make money? Because some of these companies, and let's look at why blockchain ICOs came. Because I was a blockchain company in 2014, 15, 16, I couldn't raise money. No angel investor would give me money, no bank would give me money. What was I going to do? So they built their own model to go and raise money, and it was built on things like Bitcoin and Ethereum. Now that is fine. But to guise it that you're going to build the next Google 20 and you're not going to just go and raise money was not a good thing for consumer and protect your investment. So I think myself, the regulation that I looked at was saying, you could start your life as a security. Nobody's saying that's bad. And then you might go and become a utility token and build the next Google 20. I believe personally there is very few utility tokens that I've seen that are actually just in networks that are using products. Because I look at a utility token like having my Singapore Airlines programs. What can I do with it? Other than buy a bar fridge or get upgraded, there ain't much I can do with it. But regulators
You need to switch to another airline because I can use my United miles to buy all different kinds of things.
Well, I don't.
You have to report it to the IRS.
Yeah. And I think so there was this view that we needed to bucket this stuff in one place. And I think now that...
I'm sorry to interject, Loretta, which I think is a huge mistake. And,
yes.
And this idea that something starts its life as a security and then morphs and becomes not a security, I sort of call that the magic pixie dust theory of life. Because what is the magic pixie dust that gets sprinkled on it so that it becomes not a security? And by the way, isn't there, like, if that's the pink magic pixie dust, when you sprinkle the purple magic pixie dust on the thing, does it become a security again? You can't live in a world like that because that is way too subjective a place for any business person to exist. Now, I'm not saying that people should be allowed to commit fraud. I'm not saying that certain types of capital raising shouldn't be regulated. I think all of those things are important. But what I am saying is that when you're looking at the token and what it does, that's a lot different than looking at the contract, transaction, or scheme, to quote Howie, and what's going on there. Those are two different things. And it is incredibly difficult for people to do that with digital items because digital items are intangible. They are not like oranges. You can't hold them in your hand. You can't peel them, take a bite out of them, and taste them. So people need to sort of conceptually reset the way their heads are working on this stuff because it's not the token that is the investment.
Well, it's the rights attached to it.
Well, okay, so let's talk about it that way, right? So we should talk about it as this inclusive thing, not as something that has particular functionality on a particular blockchain.
So I think we'll just move away to get onto that. But I think the one thing that these things got confused was because you don't get equity right in an ICO. Securities regulators...
Or debt right, or...
Yeah, or a debenture.
Yeah.
Securities regulators were never used to that. They've never seen anything that you don't get equity. They're like, oh, how does that work? Like, we don't understand.
But that's only because they've never bought anything on Kickstarter, right?
Well, the Australian regulator has. The Australian regulator did, but I think that's a very good point, is that they were trying to put old, like, square pegs in round holes.
Yeah.
We're starting to move through that, and I really believe that in 2017-18, that regulation conundrum we were having has moved. I'm going to move on to now, I work across a number of countries. I'm actually part of the Commonwealth. I did start my life in Australia. I won't be going back anytime soon because I tell you what, we're not going to move fast. You can tell that to my Prime Minister. But I do believe that if we have common standards and laws, and you look at the Commonwealth now with 53 countries, I've written legal frameworks in 7. I believe that if we could roll out in a Commonwealth the policy and the regulation to 53 countries that are all members of the Commonwealth with common law, because in the US, this is a problem. You've got too many regulators, too many different states. In Europe, it's a big mess. It's a big jar of spaghetti tipped upside down. But the Commonwealth has one thing, common law. And if we could do this in 53 countries, which is my aim, I believe now I don't want treaties of tax. I want treaties of technology. And I think a lot of the Commonwealth is starting to listen to me. And I think once the Commonwealth does it, you will find a lot of the US will start to follow, and Europe. So that's my game.
I hope you're right about that, Loretta, and anything I can do to help you with that. Because I do think one of the biggest challenges that we face is that the blockchain technology is global by its nature. And particularly when it's decentralized blockchain, you have people from all over the world participating on it. And the idea that you need to take account of US regulation for the US nodes, and you need to take account of UK regulation for the UK nodes, et cetera, et cetera, et cetera. It's just impractical, and it's never going to happen. Yeah. And if governments want to regulate, what they need to do is they need to band together, just as you're suggesting, and come up with
And I also think from the ecosystem, because if you're a company and you go and set up in Panama tomorrow, you're going to have a hell of a problem going back into a mature market that has better regulation. So if we could have an even playing field around regulation globally, I do a lot of work in Africa and India. They are the biggest markets in the world. So we sit in the US, I sit in Australia, Canada. You can test your market on, 26 million people? But if you have regulators that trust the regulation that sits in India, Commonwealth country now, and yesterday, I don't know if you all read, but I helped win the Supreme Court case against Bitcoin, which I think is the biggest thing that I've ever done in my life. You have Africa. Yeah, I thought that was a miracle. But you have Africa and India, and now you guys from all over the world can passport, test your markets. The regulations are assured that the regulations in Kenya or Mauritius or in London or in Australia or in Canada are the same. You have no legal recourse of that country to change the laws on you. So we're going to move on now quickly to what we think the best territories are. Obviously, I've got a bias. Where do you think, from what you see and your clients are telling you, that is the best place for them to be going at the moment?
Geez. Well, I mean, it does come back to Lee's point, which is that if you've got people who happen to have an entity somewhere else, but they're trying to sell to investors or consumers, depending on what it is, in other countries, then you're going to have to cover the jurisdictions in all of those countries. I mean, I think you're seeing, we look at it and we see three buckets of jurisdictions, right? There's those that apply the existing laws and regulations and are reluctant to change quickly. EU is...
US, Australia.
Well, US is very, I mean, I actually spoke to one of my partners yesterday who was saying that he expected a lot more enforcement action in the US over the next 3 months. That was his prediction. He's an ex-regulator, so I don't know if that's right or not. But
it will in part depend on what happens in the Telegram case. If the court goes over Telegram, then
he was expecting more from FinCEN as well.
Well, yeah.
So let's get back onto that, because
yeah.
I think the FATF, that's a different record. So
it is, yeah. So I think you've got EU applying this. You've got some countries, China obviously, that have banned, and then you've got some countries who have got this.
India, that's not now.
Yes, exactly. India, that's not now. And then you've got some other countries that have got kind of some permissive legislation, Malta, and some of those legislations are actually Bermuda, obviously, etc. Some of those Mauritius, some of those bits of legislation are obviously excellent, Loretta, and some are less than excellent in my view. And I think it is about getting that right balance of how do you fit it into the existing law. And if you look at, I do think somewhere like Malta has actually done a pretty good job of fitting it within the EU framework.
He's also the best-looking regulator in the world, so
I didn't notice that when I met him, but anyway, next time I'll note that.
Have a look.
I'll have a look, yeah. So I do think I think it is about that conundrum of how you fit it in, particularly if you're in somewhere like the EU, you're in one of these supranational bodies. I think that's a real challenge,
I completely agree with you, John, and the only thing that I would add is in some ways it depends on what your goals are as a blockchain or blockchain-related project. So if you're going to set up an exchange, there's certain jurisdictions that have made some really good laws that make a lot of sense. If what you're looking to do is set up a new protocol, maybe you would look to some other jurisdictions for that. If you're looking to do a gambling app on top of Ethereum or EOS or some other blockchain, then you're going to have a lot of challenges that other applications are not going to have. So just back to the point about sort of figuring out which jurisdiction has laws that are focused particularly on what you're trying to build is a lot of the challenge right now.
So I'm going to be biased here. So I think what we did in Bermuda, as I said, because we can passport it, what we've done in Mauritius, we've added on. One of the biggest things in this space, and it's worried me for my entire career, because when I was an asset trader in my old life, what is the big problem that we all face with the digital assets? What's the one thing that people always talk about exchanges? It's the hacking. It's the custody of this asset. Now, one banker came to me, I mentioned maybe 3 years ago, runs one of the biggest banks of Europe, and he said, "Don't worry, Loretta, we're going to hold custody of Bitcoin." And I said, "Do you know how to do that?" And he goes, "No, but we'll figure out later because we have a license." Scared the living daylights out of me. So I spent the last 18 months writing regulation around custody of a digital asset. You have no idea how complicated that is. When you have an asset that doesn't live anywhere, that it's different jurisdictional base with different regulations, with seed generations, with being able to have not one person control. Please, if you all want to go and have a read it, it's 197 pages. But I consulted the OECD, the OSCE, the FATF, another number of jurisdictions that were looking at it. So we worked with a number of jurisdictions, a number of financial intelligence units, and it came down also to looking at the beneficial ownership. Because I think with regulation, if you can prove the beneficial ownership of these companies, we solve the problems that the FATF have, we solve the problems of the security regulators, and we solve the problems of jurisdictions. So I think, in my opinion at the moment, the UK is going to come out to be one of the leaders. After Brexit, I think Boris is going to come out, and this jurisdiction is going to lead the Commonwealth with unbelievable regulation. I think Canada, I think Bermuda, Mauritius, Malta have been very, very good. I think Kenya, and the big one is going to be India in the next 6 months. They're going to come out with some very good policy because the Indians have been very slow. They're not China. China does things for very different reasons, and I think Romania and Russia. So I think these are the jurisdictions you need to look at because the regulators in these places and the central bank governors get this. Don't think they're stupid because they're not. So the next one we're going to write...
Sorry, let me just add one point to that, Loretta, and I broadly agree with everything that you said. But it's also important to remember in the blockchain space, particularly in decentralized blockchain, that you can custody your own stuff.
Yes.
And so the custody side of things, to my mind, is sort of a three-part question. Part one is, do we need any regulation for people who custody their own assets? Part two is, do we want some kind of different regulation for retail custody, people who are providing custody for retail? and third-party retail custody. And the third piece of it is, do we want some different kind of regulation for third-party institutional custody?
And we looked at all that.
And that's, that's sort of the way it all breaks down. It breaks down.
So we're now going to move on, and I think this was an issue that regulators were rapping on about a couple of years ago, when we've all just talked about. The immutability and the interoperability of blockchains. This is a very different conversation than we had 3 years ago. We were just talking about outside. Yeah. I think what you mentioned was really interesting, if you want to give a point of view on how we're starting to think this is becoming irrelevant.
Yeah, so, I mean, again, I get driven quite a lot by being irritated by things. That's one of the things about being Scottish. But you know, when people talked about the immutability and the fact that blockchain was not incompatible with GDPR, and GDPR, you know, focused quite a lot of folks' minds. And we actually, probably about 2.5 years ago now, wrote a paper on GDPR and its compatibility with blockchain, and particularly the right to be forgotten and immutability and all of those things. And actually, when you track this back and you look about how privacy law has adapted to the internet, and so we wrote this and we thought, this is actually not a big problem. You know, the right to be forgotten, you may or may not know this, is not an absolute right. It is fettered by a legitimate interest test. You know, and there's perfectly reasonable ways of getting around this. No, that said, right, privacy law is a big issue for blockchain, and it is an issue that you need to think properly about. Yep. And there is personal data on most public blockchains, both at a kind of user level and a transactional level. You know, and you've done the analysis. But we wrote this paper, and you know, at that time, having done lots of Google searches, there was virtually nothing written about it. Since then, there have been lots of academics written and various other people, and 80% of what's been written since then has been wrong. So we actually republished it and actually rebutted all of the nonsense that's been put out. You know, because people, you know, there's one very well-known academic in this area who said that every node on a network was a data processor or a data controller. You know, even if they don't do anything in a particular transaction, and just going and saying that's pure abject nonsense.
It's
right?
Rubbish.
Yeah, well, it is totally rubbish. So, you know, so obviously, I think our rebuttal was slightly more subtle than that. But you know, I think it is, you know, that kind of irritation factor for me. But I think, you know, to me, all of these problems are solvable, right? And I think we solved all of these problems in the internet age. You know, and you know, an example is if you have a website available that has personal data on it, that doesn't mean that you've transferred data to every country in the world, right? That would be ridiculous. But that's effectively what people are arguing with blockchain. So I think we do need to take these things pretty seriously. But I think these are all solvable, like many things. And actually, one of the interesting things about all of this stuff is that, you know, guess what? The regulators have managed to solve money laundering and tax.
Oh, yeah.
You know, those are the things that they have solved very quickly. Other things they're saying, well, we need to take our time. But, you know, money laundering. And, you know, I think it's actually quite good that we've got a global standard with FATF, you know, that's come through. I do think that's a good thing for the industry generally. I don't think it's all brilliant, but I do think it's, at least we've got a global standard.
At least we know what it is.
And I think that last week,
where it is exactly.
I've been doing a lot of work with the FATF. And don't forget, the FATF, the money laundering money laundering, terrorism financing bit is a very, very big part of this new ecosystem because they dictate to what we do as regulators for consumer investor protection. So we have to listen to the FATF. I've been working with the FATF for a number of years, and again, they're not technologists. So they came out with the travel rule, to talk about the travel rule. One of the companies I work with in the space has actually solved the travel rule using the blockchain. And we did some tests with the FATF. There was a hit once put out on a Japanese politician in Bitcoin a few years ago. So all the security agencies, all the security regulators that I work with, and the people from the exchanges in the ecosystem and some of the best cryptographers in the world, we geo-ring-fenced the Bitcoin. So we could actually track it. We tracked it back to the person that put the header and the computer. So this, the blockchain itself is actually very good for law enforcement. I will argue you can't trace cash, but we can trace all of this. So I think those nuisances of the regulation, the FATF been worried, are starting to calm down. And if you're looking at where it was used for money laundering and terrorism financing, that had direct impact on us as regulators, but that is starting to be solved, and the FATF, as of last week, are getting much more comfortable and understand this. Back from the, I think a couple of years ago.
Let me just add one quick point to what each of you said. To John's point and further illuminating on it, on both of your points, it's so important to remember that blockchain is just one piece of the tech stack.
Yeah.
And so when people are talking about solutions for GDPR and for other issues, they're typically not just dependent on blockchain. They're often dependent on a bunch of other technologies, which I think regulators and policymakers often lose sight of. A lot of people have this sort of view that blockchain's like this magic wand. You just wave it over things and all of a sudden everything's wine and roses, when in fact there's a whole bunch of other technologies involved.
And I think that's very important, because I don't think blockchain survive. Look, AI, people are talking about AI regulations in the country. Your AI ain't going to work if you don't have an encrypted database under it. Sorry, guys. Yeah. But I think Internet of Things, AI, technology, blockchain are all coming together now. Now, one of my great mentors in the world, and I Googled him, maybe because I'm female. Does anyone in the room know Robert Kahn? Shame on you all. He wrote the IP, the Internet Protocol, the transmission control protocol of the Internet. He sent a message over an open network to a man called Vincent. He's the father of the Internet. Please, you all should know who he is. I've asked him about this, and he said, listen, Loretta, when I built the Internet, I didn't mean to build it. I sent a message on an open network to a man saying hello. But now, on top of that, sorry, that's World Wide Web. That's
World
different.
Wide Web.
I'm talking about the Internet Protocol. So Bob Carney holds the highest civil award in the US. He's an electrical engineer. He's not a regulator. His wife was, though. And she taught me that we wouldn't have had the internet had he, as just the electrical engineer, invented it. We needed her to write regulation. She's a professor at Princeton. But the one thing I learned from him, and he said to me, listen, when we built the internet, we didn't solve the one problem, and I was told not to, was the security protocol layer. I think when Bitcoin came in, it did that. Nobody knows. How many of you got your phone on you right now? Do you know how many protocols are sitting on top of that since Robert wrote the first IP? There's now 75. You don't know that. So what you're seeing with blockchain, it's just an infrastructure. We won't be talking about this in 5 years like we don't talk about the protocol levels that are sitting on top of the mobile device. So we need to remember that. It's where the internet got very big in regulation in when he invented it. And he said to me once, he said, the US government called me in and told me to shut it down. He goes, well, I can't do that because it's open. 10 years later, every company in the US came to him and said, we need to buy it. And he goes, well, you can't do that either because it's an open network. So this is, blockchain is that as the next revolution. We won't be talking about these regulation issues in 5 years because it's just an infrastructure play. And I think that's important to note.
Let me throw out one other concept that I think is very important, and I think a lot of people lose sight of, is we talk a lot about privacy, and we talk about it in the context of corporations and our data. We don't talk about it so much in terms of governments and our data. And think what you will, I'm not taking a position on this, just identifying the issue. But with anti-money laundering regulation, with the FATF requirements, the travel rule, and all of this stuff, that is a big area of the world where privacy is not taken as seriously as it is under the GDPR. And so it's, again, not a value judgment being made. It's just something that people need to be aware of. And so when we hear, for example, government officials talk about central bank digital currencies, which, by the way, all central bank currencies are currently digital. Don't forget about that. They really mean when they say CBDC is central bank blockchain currencies. But when they talk about that, they often say, well, one of the problems there is that governments will be able to see everything that's happening on all of the transactions. Look, governments right now can see just about everything that's happening on all of the transactions. It's just a little bit more difficult for them because they have to go around to all the different financial institutions and pull together the data, or they have to go look at all the SARs that have been filed, et cetera, et cetera. So we need to be thinking about this, and that's why the digital identity stuff comes into play, and a lot of people are starting to just talk about what regulation of digital identity will look like, and I think that's a fertile area for discussion.
Yep.
But I guess then on the last thing we're going to talk about on regulations, and I think this is a big one because it helps regulators and it helps financial institutions, smart contracts.
Yep.
The ability now to use code as regulation. I think that's the way forward. Regulators won't be using current regulation, they will be using code as regulation in the next 10 years. So have you got any thoughts on how you think with smart contracts?
Yeah, absolutely. I mean, you know, I went with Lawrence and some of the GDF folk to the OECD a couple of times. I think you were there as well, Loretta, and we were talking. And I remember the first
yes.
The first discussions we were having, and we were trying to say, you know, it'd be quite helpful if we had some agreed definition about utility tokens and not all these tokens are securities and all that sort of stuff. But the other point that I thought that we did discuss earlier on was actually, in a way, you can make these easier to regulate by using smart contracts. I completely agree, and you know. You can see that with the travel rule, as you see some of the technology that's coming out now. You can actually you can have regulators can more easily,
regulation.
yeah, I mean, to your point about AML, which I completely agree with, it makes it easier for the regulator to actually see what's going on, but it also makes it easier for the regulator to actually say, well, this company is compliant because I can see the smart contract is actually doing what it's supposed to be doing.
And it gives the companies jobs.
Yeah.
And it makes the regulators active participants in the ecosystem, which is hugely important. There's a great paper that came out from the Bank of International Settlements, I think it was last fall, about embedded supervision. If you haven't read that paper, you should take a look at that paper. It's an excellent paper from a couple of academics. And the idea is exactly what John just articulated, exactly what Loretta just articulated, and it conceptually hugely important.
I think that's the biggest game change for regulation.
Yep.
This is going forward is the ability to codify regulation.
Yep.
That's from us, guys. I hope we haven't bored you too much. It's been a pretty, I'm not the normal moderator, but I think we've had a really good discussion. We've gone overboard, but thank you.